welcome. And to begin this interview with a question, I would like to ask you, how are laws crafted and shaped to meet the needs of the society? Today we have the privilege of delving into the lawmaking process with an experienced guest here, and kindly introduce yourself.
Thank you, Joy. My name is Moses Masai. I'm a graduate of law from Kenyatta University. I also hold a postgraduate diploma from Kenya School of Law. And for those reasons, I'm an advocate of the High Court of Kenya, currently practicing with the Patrick's Law Associate as an associate in the firm.
Thank you for joining us today.
Thank you.
And maybe just to begin with, what inspired you maybe to pursue law?
What inspired me the most is my background. At the time I was sitting for KCPE exam in the year 2008, the country was facing post-election violence. Too much injustice were committed in my society where I come from. And I saw that there is need for a person to be there to represent my people in courts and even in other institutions where the law as an institution governing human behavior is applied. And for those reasons, I started inspiring to become an advocate of the High Court of Kenya. And I have never set my foot back. I've been pursuing that up to date.
That is a very big cause. And my second question to you, Mr. Moses, is can you tell us a brief experience so far that you have in the world of law?
The experience I've had is that when you decide to become an advocate of the High Court of Kenya, it's not mainly a question of passing the exam very well. You can pass the exam, but law needs some passion, something outside your normal academic performance. In this case, it needs your attitude, your passion, the manner in which you conduct yourself. When those things are present, you will never struggle to become an advocate of the High Court of Kenya. To the contrary, whereby you say you have very good grades and you go into the legal profession, this field does not just necessarily depend on you passing the exam. It depends on your behavior, your character, your contact. Those are the things that will make you to be a successful advocate. Thus far, I am an advocate of 3 years experience. But discipline, passion, and commitment are the reasons why I am where I am. As of to date, I have practiced law up to the Court of Appeal level. I don't want to say that I've gone up to the Supreme Court. And my experience has been good because of passion, commitment, and discipline.
I would like to ask, maybe now that you're in this profession, is there maybe any bill that is now a law that maybe you are involved in the drafting or any other step of the process?
I've only been involved in one bill, in one bill and one regulation. There is an act called the Tea Act 2020, which is undergoing amendment. Some section of the act are being amended. I have made the proposal on behalf of 5 tea factories in Nyeri County, that is Gitugi, Chinga, Iriaini, Gaduthi, and Ragadi tea factories, where they engaged our firm for the purposes of reviewing that law, and we've given those proposals. Equally, the moment before the High Court, there are petitions which are challenging various provisions of the Tea Act, and there at the High Court I'm also representing the Tea Board of Kenya. There are proposals which have been brought in by critical players within the tea industry, and I've been the person scrutinizing their proposal and forwarding them to my client, in this case the Tea Board of Kenya. So those are at the legislative level. That is how I've been involved in the process. On the other hand, on the issue of regulation, there was also what we call the Crops Tea Industry Regulation 2020, again, which I've also been engaged by the Tea Board of Kenya to make proposal to it, especially now that we had that regulation. Now we have the Tea Act. What is the way forward to that regulation? So that only at that particular level I've been involved in the lawmaking process in this country as an advocate.
From my history class, the lawmaking process was just a walkover. It was not that deep, but I can tell there are steps from maybe it is a bill, from when a bill is presented to when it is now implemented as a law. I can only remember there was a first reading, there was a third reading and stuff like that. So I would like you to walk me and my audience through all the steps from bill to law.
Actually, Joy, we can do even much better. We can go even a little bit deeper.
Yeah, yes,
by starting even before now we start that process. we must start by, maybe it will be for the benefit of your audience to understand what is law. So law is a system of rule that has been recognized in a particular country and has mechanism of enforcing them should they be violated, or should they be violated, and also provide for remedies should a person suffer as a result of that breach. So, and laws are there to regulate human conduct, to prohibit and allow certain behavior in the society. For example, when you talk about the traffic laws, they say motor vehicle, we can have a 14-seater passenger matatu. It can only, the law provided it must be 14. Then when you carry 15, you are outside the law. So it regulates the conduct of human beings in the society. Now, that's the main reason, but equally, that's at a personal level, but also human beings also engage in a commercial transaction. I can enter into an agreement with you that I sell a piece of land with you. So we enter into an agreement. So there will be the law will come in to regulate our conduct, where you will be called the purchaser, while I will be called the seller or the vendor for that matter. So again, to regulate the way we will be interacting. If I operate outside that agreement, what are the remedies? And even with those remedies, where do I take my grievances? Then this, the manner in which we conduct ourselves is also influenced by other factors. The majority of the behavior, we talk about, change is a normal thing. The manner in which the society changes, it also influences the way we make our laws. For example, we could before this pandemic of HIV. Before we started having HIV, we did not have a law regulating or controlling AIDS in the country. But now we have it as a problem in the society. So it is the responsibility of Parliament to go and make a law to ensure that it will regulate the human conduct to suppress the spread of the disease, and also provide sanction in the event that a person engages in reckless behavior in spreading this virus. So these are events happening in the society. Also, that this, of course, this has not happened in many African countries, but mainly European countries. In terms of wars, when a country is, now at the moment, a good example will be the Russo-Ukraine war, where, you remember very well, on 22nd February 2022, Russia invaded Ukraine. And before a country is invaded, the laws are there regulating conscription into the army. But now the country has now been invaded, and therefore it requires majority of their men to go to war. There is no law. The law in Ukraine before the invasion by Russia was at 26 years. Up to a maximum of 26 years, beyond 26 years, you're not allowed to serve in the army. Now Ukraine has been invaded. It needs more men. For that reason, the law changes to increase the conscription age to 30. So the law is always made by Parliament to respond to various societal needs. Now, once these needs have been identified, they are critical. There are parties or there are persons who are involved to ensure that the law now finally found its way into the Parliament. The main proposers of laws to Parliament is always the national executive. The people are in charge of running the daily activities of a country. Remember, before a person is elected to office, he normally has the manifesto. Say, promises I will do for you. For example, the current regime promised people the issue of affordable houses. And for that reason, they came to office, and we do not have a law on affordable housing. And for that reason, when they come to power, they need a law that will allow them to achieve this manifesto. So the first person who will always go to make proposal on lawmaking is always the national executive. Now, equally in the National Assembly, there's also a political party. The political party maybe that lost the election. Let's say, for example, the Azimio One Kenya coalition that they became second in the last election. They could also want to have their manifesto implemented despite them not being in government. For that reason, they can also propose a bill in Parliament. Another group of people, when Parliament has been elected, there are always these committees of Parliament, maybe the Committee on Health, the Committee on Defense, the Committee on Foreign Affairs. They could be responding to a particular need. For example, now, in respect to the Russo-Ukraine war, let us say Kenya joined the countries in the West that are sanctioning Russia. The Committee on Foreign Affairs will have to develop a bill to pass a law that will specifically allow Kenya to sanction Russia. That is an example I'm using. I'm not saying that has happened. So there is always a department of Parliament that will always propose laws, and it will become a bill and then to be taken through stages. Now, with the passage of the 2010 Constitution, it allowed more participation of the citizen into the governance of the country. And that's why when you read Article 10, Clause 2, provide public participation as a national value and a principle of governance. For that reason, members of the public, in their capacity, they can also propose laws. They can also petition Parliament to pass certain laws. So, for example, you can say university student, they have seen now the current system of election at the university level through the electoral college. The university student, they feel now that the laws under the Universities Act is unfair. It does not allow them, maybe they want to go the first past the post system as opposed to the electoral college. So students of the university can come together through their union or through their association or in their individual capacity. They can petition Parliament to pass a certain law. And then apart from that, key players within a particular sector. Now, for example, the law was giving you the players from the tea industry. The Tea Act, actually, it is a brain of the tea farmers. When you saw Senator Aaron Cheriot, when they were making this proposal in the Senate, when they were presenting this bill in the Senate, they said that we have spoken with the farmers, and they were now telling us that we must pass such a law. So there are those laws which are sector specific, those on affecting tea. When you go to the western region of our country, there are sugarcane farmers there. They also, when you come to tea growing areas, we also have the coffee farmers. We also people involved in manufacturing. We also people involved in running private institutions. So they could also have their laws, and they will be justified to propose the law. Now that is how now a bill will come into being. Now once the bill comes into being, it is communicated to Parliament. It's communicated to the Speaker of Parliament. But of course, it is always taken to Parliament through the Clerk of Parliament. Now, maybe I must also make one clarification at this particular point. In Kenya, when you're talking about a Parliament, when you're talking about Parliament at national level, you're talking about two chambers of House. You're talking about the Senate. You're talking about the National Assembly. In law, we call it bicameral legislature. You're talking about a Parliament that has two houses. When it is one, it is called unicameral, only one house, the one that we had before the passage of the 2010 Constitution. So when the bill is taken either in the Senate or in the National Assembly, it will be communicated to the Clerk of the House. It's called the Clerk, and then the process of lawmaking will start with the first reading. The first reading, the Clerk of the National Assembly reads the bill to the House. So, for example, when the Tea Act was being passed in 2020, the clerk came and said, the Tea Bill 2020 has been presented before Parliament. Now, at that particular point, it's just reading. Then the bill is given a tracking number. So now this bill will be called, maybe it will be, there is a way in which these bills are given numbers for the purposes of tracking them and also for the purposes of record. So at that particular point, it's just the House is being informed that we have now a bill. Then from the first reading, and at this particular point, I must also point out that voting is not involved, debate is not involved. From the first reading, the bill goes now to the second reading. At the second reading, it is now that's another point where now, if you normally, when you look at the debates at the high school, when you talk about the opposers and the proposers, that normally happen at the second reading. At this particular stage, the owner of the bill makes a case. See, for example, now at the moment we have the affordable housing bill being debated. Yesterday it was not the second reading. It was being voted for. At this particular point, the mover of the bill. The movers of the bill are always the leader of majority, and that is from the coalition that won the election, or the leader of the minority, that is the coalition that came second in the election, or the individual member of Parliament who is proposing that bill. That person is given an opportunity to make the case for the bill. So, for example, the affordable housing, they are saying their case they are making before the whole nation is that we need to pass the affordable housing bill so that we can allow majority of the citizens to be able to access houses. And while in the process of us making them to access houses, we are creating employment opportunities to our youth. And they also say, while we create also employment for the youth, we are making them to earn a living. And because they are earning a living, they are getting something for their retirement benefit. They are getting something for their NHIF. So that is what a person making the case. So once they make the case, the Speaker of the House always leave the floor open now. The bill will be debated. So there will be proposers and opposers of it. So there will be people taking chances, opposing and proposing the bill. But at that particular point, they will be voting at the end. So there will be people who will be voting. The people who support the bill, they will vote for it. Those who oppose it, they will they will vote again, they will vote no. It's always voting yes or no. Now, for example, for the affordable housing bill that was there yesterday in Parliament, we had 141 voting yes and 58 voting no, meaning that the bill has now passed the second reading, now moves to the next stage. And the next stage is called the committee reading, the committee stage. At the committee stage, the bill is taken to the specialized committee of Parliament. Now, for the case of the affordable housing bill, it's taken to the Parliament, to the National Assembly Committee on Housing, Urban Planning, housing, urban planning, and transport. That is a specialized committee of Parliament. So once it's handed over to that committee now scrutinizes the bill. It looks at the bill clause by clause. What does this clause mean? What will be its implication? Remember, when you're passing a bill like the affordable housing bill, it has the impact of affecting other laws. Maybe it has an impact on Finance Act. It has the impact on the National Health Insurance, and on NHIF, on NSSF, or on education. So it will be scrutinized. Every clause will be looked at with the clear details, with expert information on it. It will be looked at it, and also to test its implementability. So that, for example, if you are passing the law, how implementable is that law? So that you don't. Now, for example, yesterday when the bill was before this affordable housing bill was before the house, there is a senator from the women representative from Homa Bay, Honorable Bensouda. Honorable Bensouda opposed this bill, saying that, look here, this bill is not implementable. So when it goes to the committee stage, then the National Assembly Committee on Housing will have to ask itself the issue of implementability. Is this bill implementable at that particular stage? So they will go to it clause by clause. And always when you're following parliamentary proceeding in the country on that particular date, the house is not always presided over by the speaker. Always the deputy speaker or the chairperson of that particular committee. So the house will debate this bill clause by clause. And then at the end of it all, there will also be a voting. So again, once the committee stage has been voted, the bill goes now to the next stage, which is the reporting stage.
Before we go maybe to the reporting stage, Mr. Moses, allow me to cut you short.
Yes.
We go for a break and we'll be right back. And I know we are learning a lot. Especially my audience and I know we are learning a lot in the world of law. But I sit here and ask myself, so far, we have reached at the committee stage, right? Maybe in a law, when a law is passed,
yes,
are there loopholes? You will answer that after the break.
Knowledge is power that we seek every hour and gives us a reason to aim higher. But where do we get this knowledge? From in-depth research, literature books, to reference materials. Great Minds Library gives you the opportunity to grow intellectually and get the information you seek, as well as help you maximize on your reading hobby. Visit us today for quality services at 100 bob only per day. We have partnered with Nibs Technical College to make this a success. We are located at Ruiru Kimbo along Thika Superhighway, exit 13 next to Kimbo Stage. Great Minds Library. Instill knowledge with us today.
Welcome back, and as we continue to delve into this lawmaking process, I had a question before we went for the break. Maybe are there loopholes? Maybe you can answer that before we continue with the other steps.
There are always loopholes in a bill, and also that's why it is lawmaking process. Part of the lawmaking process is to identify those loopholes. And as we were before we went for break, we had just come from the committee stage. The loopholes are supposed to be identified at the committee stage. That's why when I explain the committee stage, the bill is scrutinized clause by clause. So that, for example, the T Act had 40 clauses when it was coming at the committee stage. So the legislature scrutinized all the 40 clauses. So they read one clause, then they discuss it. You read the clause and then you discuss it. for example, let's say clause 34 in that bill talking about the management agreement between a tea factory and a management agent, in this case mainly Kenya Tea Development Agency Holding Limited, KTDA. It's always the main management agency. So they look at the bill. What are the services that a management agent can give to a tea factory? Can it give it the company secretarial services? Can it give it the auditor services as at a factory level? So the bill look at those loopholes, and from those loopholes, the bill at that stage they try to be closed. But at that particular point, amendments are not allowed. Now we come to the reporting stage. At the reporting stage, the bill having been scrutinized at the committee stage, now it comes at now the reporting stage. There are those amendments now which comes in. Now, for example, I have mentioned to you when the Tea Act was going at the third reading stage. At the committee stage, it had 40 clauses. Now, when it is coming to the reporting stage, those clauses increased up to 74. Why? Because in filling those loopholes, there is always need, maybe you increase one clause to address a particular issue, or you remove a particular clause to make the bill conform to other laws. The way I've mentioned to you, one act of parliament can affect the function, or can found itself working with other laws. Now, for example, the Tea Act, it will certainly bring in the role of the county governments. So what is the role of the county governments? And then it brings in the county government working with other national institutions like the Tea Board of Kenya. So that interaction is always dealt with at the reporting stage. And at the reporting stage, the bill now is put now to the House. It is now the whole House now debating the bill, making those amendments. Then finally the bill will be subjected to a vote. And once the bill is voted for at the report stage, it goes to the third reading. And the third reading is now the final stage. At that particular point, no amendments are allowed. The bill is just debated, and then the question is put before the House. And if the House passes the bill now moves to the final stage, which is presidential assent. At the presidential assent, the bill is taken to the president, always by the Speaker of the National Assembly, accompanied by the Honorable Attorney General and the leader of the majority or the leader of the minority. They are the one who normally accompany them to take the bill to the president. At the presidential assent stage, it is also we can say it is a mini law-making process. Remember, the president is not law-making under the Constitution is work of Parliament. Now, president is coming in to sign. At the presidential assent stage is where now there is also some mini law-making processes there. Because the president, the three things can come out of that from that stage. One is whereby the president accent to law. Okay, the bill is good, like the Tea Act. It was good on 24th December 2020. President Uhuru Kenyatta appended the signature. The bill comes into law. But there are those instances when the president, having looked at the bill, he say he does not agree with a certain section, or the bill does not cater for his needs as an executive, or as the chief executive, or as the chief executive of the country. So in that case, the president is given by law, by the Constitution, allow the president to return the bill back to Parliament with the reservation, saying this particular section, it should be amended in this particular way, so that it can cater for this particular need. So the bill will be taken back to Parliament, but with reservation. At that particular point, it is not law. It has just been taken back to Parliament. Now, once the bill is taken back to Parliament, the decision will be communicated to Parliament by the Speaker. So the Speaker will tell them the President has not ascended to law, but he has given this reservation. With those reservations having been read to Parliament, Parliament has two options. One, it can still pass the bill in the same state, in the original state it was, before sending to the President. It can still do the same and send it to the President. Two, it can pass the bill now, this time round, accommodating the reservation that have been proposed by the President. So that's the second. The other lawmaking process is what happens when the President now decides now he has received the bill and is doing nothing about it. What happens? What does the President does? Now the Constitution provides that upon the President receiving the bill, 14 days, with the lapse of 14 days, the bill automatically becomes law. His assent notwithstanding. So it becomes operational. And I think maybe for the benefit of your audience, you must have heard the previous government, President Uhuru Kenyatta's government, having problem with with the appointing judges. He's given the name of the judges and he started to sit on them.
Does not appoint.
Yeah, so that's actually the argument that was being used by the court to tell the president that once you receive the name of this judge. Remember, in this matter was litigated. I think this matter is the most litigated matter. Starting in 2015. 2015 there was a litigation. 2016 there was a matter also in the court. 2020 there was also another matter in the court. Then after 2021 there was also another matter in the court. Now for the one in court in 2021, it was asking the before the High Court Constitutional Division, the question before the court was whether what happened after 14 days when the president has received the name of the judges and he refuses to appoint them. So what do? The court said that because under the constitution, the president, after 14 days when the law has been passed, and the president does not assent to it, it automatically becomes law. The court ruled that immediately the president received the name of the judges, and the 14 days lapses, and the president does not appoint them, they must be deemed to have been appointed by operation of
so
the
it just
law.
becomes implemented with or without his signature.
Without his signature. So in that case, the chief justice will take the name of those judges and then he start assigning them in various stations across the country. So that is basically the law-making process.
And to the next question, after now we have digested the process and it is very informative, and I would like to ask maybe the stakeholders or the people there in the law, in the world of law, what role do they play in shaping and drafting legislation?
First of all, law-making process is the area where, and I hope we talk about stakeholders in the stakeholders in this case. I talk about the advocates,
advocates. And any other, that might be there,
or any other agency that is involved in lawmaking process. So you need to know that in the legal sector there are so many players. The main players being advocates, but we also have institutions that which are critical in law making or they just participate in law making. And in this case, you're talking about the civil society. For example, now relevant to your profession, in the Media Council of Kenya. The Media Council of Kenya is a critical player. For example, you are passing the laws affecting the media services or the conduct of the journalists in the country. They will always come and participate in it. Maybe a good example will be in 2015. We had the Ministry of Communication, Information and Technology causing that shift from analog terrestrial transmission to digital terrestrial transmission. I think you remember that time when all our televisions went they went off because they were to go digital. That is the time when we now started feeling Dr. Fred Matiang'i. So these players, they are always there to exercise what we call oversight and being the conscience of the society. You know, these are like prophets. I hope you've heard the stories of the prophets in the Old Testament when God used to say to them. These are people like that. Remember, not everybody can access this information. It's only this group of people, and they are supposed to do this in utmost fidelity to the Constitution and to the people in whom they represent or whom they purport to represent their interest. So their main role is always to exercise oversight and bring sense. And also to point out that, look here, Parliament, you are breaching the law. While you are passing this law, like now already the affordable housing is already facing opposition. First, opposition from the minority party in the National Assembly, and also facing opposition from various civil societies in the country. So they are supposed to exercise oversight. Now when it comes to drafting, that is the role of advocates. They are the one now mainly engaged in drafting of these bills. They draft the law, they make those amendments. They are also the one, again, very important that maybe I did not mention when we are looking at the lawmaking process, at the first reading stage, once the bill has been given a track number, it is always allocated to the relevant committee of Parliament. Remember the way we started to say that a member of public could petition the Parliament.
a civil society could petition Parliament. And when they petition Parliament, they are doing this in their capacity, individual capacity. They are not members of the National Assembly. So when the bill goes to Parliament, it must be taken to a relevant committee. So if the bill is on matters of health, it will go to the Parliamentary Committee on Health. If it's a matter on defense, it will go to Parliamentary Committee on Defense. Or it is on education, maybe it's basic or higher learning, there are those committees in Parliament. So it will be assigned to that committee. It will be the responsibility of that committee to hold or organize what we call public participation. Now, public participation is a national value and a principle of governance. When you read this constitution, Article 6 of the constitution say that Kenya is a multi-party democratic state founded on the national values captured in Article 10. Article 10 goes on to mention the national values, and Article 10 clause 2 of the constitution mention public participation as one of the values. Throughout the constitution, when you read the various provisions of the constitution, Article 119 of the constitution provide that public participation. Article 118, 119 of the constitution provide when National Assembly is enacting legislation, it must involve members of the public. When you read further up to Article 296, again, there's the role of the county assembly. They are supposed to involve the people in lawmaking process. So when you talk about the players in this sector of lawmaking, while we have those critical players who bring in the technical skill, expertise, but we also have now the stakeholders as the general citizenry of the country where we are supposed to participate in it. For we advocate, we also have we are also privileged. Every time there is a law that is being enacted or being amended, the Law Society of Kenya is always given those laws, and then the Law Society of Kenya always send email to us, to our individual email as advocates. So we'll always wake up one day in the morning, I found there is a bill being passed in Parliament, and they ask us to submit our memorandum or our proposal to the same. So that's the role of the various players in the lawmaking process.
Okay, and in this process, in the lawmaking process, maybe are there compromises, maybe in Parliament or at whichever stage to meet or to reach the consensus?
That is a very, very brilliant question, Joy, you've asked. Actually, that is a very brilliant question. Compromises. Lawmaking, it is undertaken by Parliament. Parliament, while it is a creature of the Constitution, it is an institution that is run by politicians. And the politicians always enact these laws while they speak in the best interest of the citizen, or they claim to speak in the best interest of the citizen. Many of them, sometimes there is also personal interest or coalition interest. Now, at the committee stage, when the bill is being scrutinized, clause by clause, or at the secondary reading, when the bill is being clause by clause, at that particular point, it is always advisable the proposers of the bill to reach out to the other party, or to reach out to the other side, and ask them, now we have this bill. Yes, you are in Azimio, One Kenya coalition, and we are in Kenya Kwanza. Now we have this affordable housing bill. We also, now the main argument at the second reading, they were saying that, look here, we saw your manifesto. You also had the affordable housing bill. Now we have our affordable housing bill. Why can't you bring in your proposal so that we can put them together and have a bill? So that is now the point where compromises come in. And also compromises also come in so that to allow this bill to sail through. Remember, it requires voting. So what do I get from what do I get from this bill? So it's always that compromise. So compromise always come at the committee stage. That's where the compromises always come in, and the minority side. Remember, we don't have the opposition. We've never moved away from the parliamentary system where you have the opposition and the government. We normally have the minority and the majority side. The majority side always the government, and the minority side always deemed as called the opposition. Their main argument at the second reading, they were saying that, look here, we saw your manifesto. You also had the affordable housing bill. Now we have our affordable housing bill. Why can't you bring in your proposal so that we can put them together and have a bill? So that's now the point where compromises come in. And also compromises also come in so that to allow this bill to sail through. Remember, it requires voting. So
what do I get from what do I get, what do I get from this bill? So it's always that compromise. So compromise always come at the committee stage. That's where the compromises always come in, and the minority side. Remember, we don't have the opposition. We've never moved away from the parliamentary system where you have the opposition and the government. We normally have the minority and the majority side. The majority side always the government, and the minority side always deemed as called the opposition. The minority can also bring in their proposal, and we then bring their proposal on table. The bill is likely to sail through, considering now that it is being run on what we call on bipartisan stance.
Maybe a good example where bipartisan has been involved. Let us look at the U.S. Congress today. The moment the U.S. is funding is funding 3 wars. It's funding the war. It's funding Ukraine to fight Russia. It's also funding Israeli war against Hamas, and it's also supposed to fund Taiwan so that to make Taiwan to be in a position to give Taiwan capabilities to defend herself should China ever invade and take Taiwan to itself. Now there is that bill. To make it a bipartisan bill, the House Democrats, remember Democrats are controlling the House, the White House today.
What they have done is that they have added some money on it, saying that now this one will be for us to control the border.
The border is not an issue of Democrats in US. The border is an issue of Republicans.
Yes.
So they have brought in the issue of money for border so that and make it one bill package. So that a Republican will be enticed to pass the bill because it will deal with the issue of the border.
While a Democrat will be enticed to pass the bill because while they don't care about the border issue, but they will enable their party, which is in power, the White House, to fund the Ukraine war, the Israeli war against Hamas, and properly defend Taiwan. In that case, they get a very good foreign policy standing before the voters as they head to election.
So bipartisan and the compromises are normal in lawmaking process because it's a political process.
Okay.
It's primarily a political process.
Okay. So in everything that is done, everything that is there must be challenges. So what are the challenges in the legislative world?
Now the challenges, the first challenge that we've seen in the legislative process is just treating the citizen of a country with contempt.
You see, the Constitution said that the way Article 6 provided Kenya is a multi-party democratic state founded on national values and the principles of governance captured in Article 10. Article 10 provided public participation as one of the values and the principles of governance. Now, total contempt to citizens is whereby Parliament decided to pass a law without involving the citizens.
They just decided to pass it. Citizens, they're just left out. And also for that reason, that presents now the greatest challenge to lawmaking process, in that without public participation, the bill will be subjected to a judicial process at the High Court by way of filing a constitutional petition. I'm very sure you are aware that the Finance Act, the provision of the Finance Act dealing with the housing levy have since been declared unconstitutional by Parliament.
When it was found established that there was public participation, but the manner in which the housing levy was inserted in the Finance Act 2022, it was so unconstitutional that it was violating the basic laws on taxation. For example, one of the things, the way I told you, when you look at the lawmaking process, the bill will always affect another law. Now, the housing levy, they said that it could be collected by KRA, and they were calling it the housing levy. The High Court found that, look here, any levy that is charged in this country, it cannot be collected by KRA. It can only be collected by the Cabinet Secretary. And at a particular point in charge of a particular department. For example, for the issue of housing levy, it should be collected by the Cabinet Secretary for the time being in charge of matters housing. And it is done through a gazette notice. But the housing levy was being collected by Kenya Revenue Authority, meaning that a state agency was performing an illegal task. So that this one for me is to explain to you that the next challenge that the lawmaking process faces is either people ignore the advice of their advocates or they engage the services of utterly incompetent advocates. Because you're supposed to, when you look at the law, you must look at it from a very broader perspective. But many times, of course, government always ignore advice from advocates and then they just go ahead and do it. So those are challenges. The once there is no public participation and the law is enacted in a manner that violates other laws, it will be subject to a judicial process. And what will be the outcome? The law will be declared unconstitutional. Now, there is one act called the Contempt of Court Act. This was an act that was passed by Parliament. Parliament did not conduct public participation. And in enacting that act, Parliament violated the Constitution. For example, it tried to now restrain the functions of the judiciary in administration of justice. When the act was subjected to a judicial scrutiny in 2017, Justice Chacha-Mwita of the High Court declared the entire act, the entire Contempt of Court Act, was declared unconstitutional for those reasons. So, the lawmaking process will always face those challenges. And once an act has been declared unconstitutional, it is not operational. Parliament is taken to square one again. And that's why now we're having now the Affordable Housing Bill. Why are we having the Affordable Housing Bill? Because the Housing Levy in the Finance Act was declared unconstitutional. So those are the challenges.
Okay, thank you. And maybe you can give us a very brief insight on maybe does issues like lobbying have anything to do with the lawmaking process?
The
Issues of lobbying, matters of lobbying.
Yes, actually, the current president is the greatest lobbyist when it comes to lawmaking. The way you remember before the Finance Act 2020 was passed, he said that I'll be looking at the MPs who will not vote for this bill.
I'm waiting for you to vote no.
Yeah, I'm waiting for you to vote. You remember that?
Yes.
Then for this housing bill, he has already said that you must pass this bill by Tuesday because these youth are ready for work. They want work. Yes. So lobbying is always there, and it is the best way of doing lobbying is as long as you do it legally and constitutional without those. But of course, in this things, the president look very coercive and also very forceful. But if it is done properly, this is actually what normally happen in the US. In the US, because those are mature democracies, lobbying is always there. The president will always reach out, and it is always a give and a take. Okay, allow us to pass this bill, but then we as the government will do for you this. So it's always a give and take. So lobbying is always very important in that lobbying is very important. That it is always the basis of bipartisan. You can always go and lobby for a certain member. But for example, when you look at the Affordable Housing Bill, I have seen an MP by the name. There's an MP by the name Shinali from Kakamega. He's not a Kenya Kwanza MP. He's not. He has voted yes. He has voted with the government. Meaning that somebody must have lobbied for him. Somebody must have lobbied. He must have been told that you vote yes. In exchange, maybe we build for you a road in your constituency, whereby when we come to launch, or where we will not come and launch the road, you will go at the launch and say, this is how we've been utilizing the city. I'm just saying an example. I don't know the details of negotiation. The greatest, now, to answer again your question, the danger that comes with lobbying is that with a society with the weak laws, with the collapse morals in terms of corruption like ours, lobbying can take the form of corruption. You must have had MPs. There is an MP, Sirisia member of parliament. His name is John Waluke. He has confessed in broad daylight that they were paid 100,000 to pass a particular law. You must have heard Moses Kuria saying that before they removed the Eden Duale as the leader of majority in the previous parliament, they were getting paid. So lobbying is lawful. But lobbying can also be abused and become a very corrupt scheme whereby MPs are paid to pass bill. In that case, the interests and affairs of the citizen of this country are trampled upon, and they don't make sense at the end of the day. And for these are some of the reasons that from where I sit, it has made our parliament to be the weakest link in implementation of the 2010 Constitution and defending the interests of the citizen of this country.
I would like to, as we wind up, I would like to thank you for joining us today, and I would like you to give a parting shot to the audience. And for that, in the parting shot, I would like you to include maybe the farm that you work with, and maybe is there any material that you would recommend law enthusiasts to maybe read on this topic?
Yes.
My parting shot, just to answer your question, I work with the Patrick's Law Associate. It's a medium-sized law firm started in 2001 by the founding managing partner, that is Mr. Patrick Ngunjiri. We are located in Kimathi Street, and our firm handles all matters. All matters. We handle commercial, commercial transaction, conveyancing, litigation, divorce, succession. We handle all matters in our firm. We have a very dedicated and a highly motivated team of advocates. My colleagues, can you imagine? These are the people who trained me when I was a pupil. They are the one who are training me to become an advocate. And at the moment, I'm an advocate who can even go to appear before the Court of Appeal and make my argument. So it's a very wonderful firm, and it has also been a very good ground for my growth as a profession. For the law enthusiast, for you to become an advocate, you must be a conscient. You must be a conscient of the society. For you to be a conscient of the society, you must be on top of the society. You must always know exactly what is happening in the society. Actually, if you are of course, now in this case, you want to become an advocate who goes to court and litigate, or who want to participate in the lawmaking process. You must actually be on top of everything. So, for example, at the moment, if you ask me what is the most trending issue going on at the moment, I'll tell you the Supreme Court today has delivered a judgment in the SSF Act. Has delivered it today. You see, I'm on top of it. You cannot afford to be behind the news. Actually, an advocate, when people are reading the news, you should be getting the news. It should not be news. It should be some information being passed to you, which you already know. So that's for an advocate. But again, if you want to become an advocate, you are not necessarily supposed now to come to court arguing cases from the High Court or from the defending people. No. You can also be an in-house counsel. You work with a corporate society. You can become the chief legal officer of a bank, of a cooperative society. You can become you can be in charge of you can be the principal legal advisor of a government department, a ministry, a state corporation. You can be a legal officer in those departments. And for that reason, it does not require too much, although as an advocate, still the demands of an advocate of being passionate, disciplined, and committed will still be required of you in one way or the other. Now, do you want the material you're supposed to read? You are supposed to the material you're supposed to read is that you need to read judgments. Judgment. For example, the judgment on the housing finance is now this is a common judgment. Immediately the court delivers the judgment. It's always circulating on WhatsApp. Try to read them. You're also supposed to read also books. This majority of the laws, they have some origin in the book. I remember when we were in fourth year, when we were doing a unit called jurisprudence. Jurisprudence is the philosophy of law. In this case now you are investigating. Where did we come from? Where did this idea of law come from?
And you see now we are now meeting people like Thomas Hobbes. Thomas Hobbes is a legal theorist in Europe.
In the medieval period in Europe, he's the one who started defining law. Now, when Thomas Hobbes defines the law, where was Thomas Hobbes himself coming from? You see, he was coming from the book of Job, the Lavethian. When you read the book of Job, the book of Job in the Bible, the Lavethian theory of the law, it originated from that book. And this reading of the Bible, the 10 Commandments, the manner in which they are phrased. You can also read actually the book of Leviticus, the manner in which the regulation that Moses was given to give the children, the way the manner in which they are framed actually in the legal sense. You can also read the book of Ecclesiastic. The book of Ecclesiastic actually is also law, and we apply them actually in our arguments. For example, when you read there is a judgment by the High Court Justice Mabea, the High Court on the judgment on the estate of Njenga Karume. You see, the judge says that he opened the judgment and said that in the book of Ecclesiastic chapter 3, say there is time for everything. Time to be born and time to die. Then he goes and say that on this particular date, so and so did what? Died, leaving behind this estate. And this estate is the one that is subject of discussion before this court. So you need to read. You also need to read these books by Shakespeare. Shakespeare is a very good book. When you read, I would recommend you go and look at the YouTube clip on the BBI judgment. Look at the Court of Appeal. There is a Court of Appeal judge called Justice Patrick Kiage. When he was reading his judgment, when he was talking about the BBI bill as dismembering the constitution, just to quote him exactly, this is what he said. He said, dismemberment is dismemberment. It matters not whether you effect it through rough mutilation or surgical mutilation. Then he goes and said that it does not matter whether you carve Caesar as a dish meant for the gods, or you use him as a carcass meant for the hounds. Then he say in both cases the cats are eternal. He was quoting Shakespeare, Julius Caesar. You see that? So you need to, and that's the reason why for you to be on top of these things, you need to read a lot. You need to be properly informed, and for that, in that way, you will motivate yourself to become an advocate. And also keep good company. Keep a good company of people who are enthusiastic in doing law. You keep that company. That company is the one that will keep you moving and moving. Yes.
Okay. I have been your host, Joy Maina, and remember, stay informed and advocate for positive change.